Hello, dear colleagues and friends. Good to see you with Margaret, Burkhard, and Enrique. I am happy to welcome you to this sixth CPLJ webinar. We will have the privilege to hear two outstanding and prominent scholars, Bruno Dauphin first, Remco van Rij secondly. As you know, this webinar, as well as the previous sessions, are intended to put into perspective the two first segments of our editorial project, respectively devoted first to comparative studies and the relevance of categories, and secondly, to civil dispute resolution from a pluridisciplinary perspective. In this framework, since the first webinar, we dealt with methods of comparative law applied to procedural law. We wondered whether legal families in comparative procedural law were still a valid approach. We supplemented this question with a reflection about comparative law in the age of the past and about acts of comparison from a political and ethical perspective. We turned afterwards to comparative procedural law and culture before taking a view of comparative procedural law from practice. Then we considered trans-procedural substantive norms across time and domains, and we widened our gaze with some anthropological insights on extrajudicial dispute resolution in Europe, which allowed some comments on the impact of religion and tradition. Finally, we tackled the sensitive issue of decoloniality, and we wondered more about the historical and political factors influencing civil dispute resolution. Today's session is a continuation of the last webinar from which it separates, however. Continuity first. Continuity, first of all, because we will remain on the historical ground by asking ourselves whether there are lessons to be learned from history regarding the use of foreign models of civil national law reform. This is a difficult question for many reasons: political reasons, cultural reasons, technical reasons. One could evoke here the myth of the foreign legislator. Separation, nevertheless, as we are going to venture into a land unfamiliar to traditional processualists, I mean economy. However, the economics factors in the evolution of civil procedure are far from being a new phenomenon, but they have been neglected by the doxa, while in the contemporary period, they have taken on quite considerable and decisive importance with the managerial turn of justice. Finally, economics and history are not so far apart in terms of civil procedure. As the program indicates, economics will open our webinar with the first contribution entitled Comparative Procedural Law and Economics, presented by Bruno Dauphin. Bruno is an economist, one of the most famous French experts in law and economics, in particular in the field of the efficiency of legal systems, litigation, of course, but also property rights, contracts, liability, law and finance. He is a full professor in law and economics since 1998. He teaches at the University Paris II Panthéon-Assas, where he is the director of the Paris Center for Law and Economics. Bruno is an honorary senior member of the Institut Universitaire de France, a visiting professor in many universities in the world. He is the author of an impressive list of books, research reports, and so many papers. I especially mention the material of the conference he organized 20 years ago, it's a long time, on law and economics in civil law countries, which is, I think, a reference book. It's my pleasure now to give the floor to Bruno.
Thank you very much, dear Loic, dear colleagues, dear friends. That's my pleasure to participate to this nice webinar. So I thanks a lot Nicole, who will help me for the slide presentation, because we have some technical difficulty to share the screen. So Nicole, if you could, thank you very much. So yeah, today I will introduce a general discussion about comparative procedural law and economics. Maybe you can go through the slide just to have the very first. Yes, I just want to introduce the discussion. We were talking about history. So this is a nice sentence by Alexis de Tocqueville in the Democracy in America. English or American lawyers are looking for what parties have done. French lawyers are looking for what they should have done. The first system produced precedent, and the second, motivations. I like this this view of to introduce procedures. So, of course, my presentation is not about history of thoughts about procedures, because my colleague will introduce the discussion in a few minutes. So maybe we can go to the next slide. Yeah, first I would like to define the way economic analysis is talking about procedural rules. I suggest for this presentation a very general view about the topic. My opinion is that when we speak about economic analysis of procedural rules, we are talking about the way we can study how rules modify, alter the incentives of litigants to file, to settle, to litigate disputes. There are two dimensions I will speak about. The first is probably the most classic economic view. This is a micro analysis of procedural rules. It refers to two separate questions. One is about the way procedural rules affect private costs and benefits of litigation. It is the micro level because we are looking on the values, expected gains and losses faced by plaintiffs and defendants. But it is not the only question. We are also interested as economists by the way procedural rules affect the social cost and benefits of litigation on the direct and indirect cost of litigation. By direct cost, I will, for instance, consider efficiency question, how procedural rules could contribute to the efficiency of the legal system in general. But there are also some indirect costs, external costs, like the cost of errors of litigation, type 1 and type 2 errors. I will speak about this point in my presentation. Now, for the second part of this presentation, I would like also to introduce some different perspective. This is a more recent way to consider procedural rules. I mean macro analysis. Macroeconomic effects of procedural rules. When you consider, for instance, the impact of legal procedures, you consider that law matters. Law is non-neutral on the economic outcomes at the macroeconomic level. So how can we demonstrate the real impact of procedural rules using, for instance, some empirical material via economic or legal indicators? I will try to give you some clear ideas on this point. Next slide, please. So first, considering the macroeconomic analysis of procedural rules. The very first question is about litigation. And more specifically, I would like to just to recap the topic considering the probability to settle a case rather than to go to court and to wait for a judgment. There are some pioneering works in the beginning of the 70s by some authors. I suppose you know maybe Richard Posner. When you speak about law and economics, it's quite difficult to ignore Posner. But he was not the first. There are two previous papers by Londes, 1971, and Gould, 1973. We are talking about economic model of litigation. The question is, how could we explain the way litigants behave to solve disputes? There are different categories of models. The very first models is about optimism, the role of optimism. If you prefer, we as economists, we try to explain the importance of beliefs, if you prefer even more precisely, probabilities. Probabilities to win the case or to lose the case on the decision to settle or to go to court. The fundamental notion in this category of models is the cooperative surplus. The decision to cooperate or not to cooperate depends on your beliefs, and more precisely, on the way your beliefs are designed. I mean, are you optimistic or pessimistic players? The points that have been explained in the 70s is that optimistic people will fail to cooperate. Why? Because optimism, if I consider that my probability to win the case is very high and you think that your probability to lose the case is very low, we cannot cooperate easily. So on the contrary, pessimistic beliefs will help people to cooperate because the cooperative surplus will increase. The problem of these models is that it takes beliefs as given. We have no explanation about the origins of beliefs. Why are you thinking that your probability to win is high or your probability to win is low? There is no explanation. We just observe the consequences of beliefs on the probability. So that's probably the reason why 1 or 2 decades after this first generation of models, we observe a new way to think about litigation as economics. I mean, strategic models. In that case, you will concentrate on the role of information, and more precisely, informational asymmetries, to explain litigation strategies. The point is quite simple. When I have private information, I'm, in a way, I try to benefit from my private information, and it will constitute maybe a failure to cooperate with the other party. Of course, we have many theoretical papers as well as empirical papers on that topic. I published many papers using thousands of data on that point to evaluate the intensity of informational asymmetries in the strategies of litigants. And I observe that in many cases it is relevant, particularly for business cases, for corporate law cases, or for liability cases. But if you look at the family or labor litigation, it is not so clear. That's probably the reason why in the more recent period, we observe a new generation of models when economics meets psychology. It is a role of cognitive biases to explain why it is in a way a comeback to the role of beliefs, but you explain the belief using cognitive biases. I will not insist on that, just to give you some general intuition. So, referring to these models, we have many possible extensions to look at the specific impact of some characteristics of procedures and the probability to settle the case. I mean, for instance, cost and funding of litigation. It's quite clear in this type of models that the more expensive is the case, the cost of litigation, and the more important will be the cooperative surplus. Because if you decide to settle, you will escape to this cost. The question is not only about the amount of cost. We can also consider the cost of the allocation rules. For instance, American versus English rules, just to look at the impact of the way the litigation costs are allocated between the parties. Is each party pay for his own cost, or do we have some possibility to impose all the cost to one party, the loser, of course? We have also possibility to look at the amount of damages. That's quite clear that the higher is the amount of damages, the higher will be the probability to settle the case, because the surplus will increase. Discovery rules are playing a very significant role also, because via discovery rules, you eliminate informational asymmetries. In a way, discovery rules means that you impose common knowledge about the characteristics of the case. So it will facilitate settlement, contrary to what you observe when there is no such procedural system. There are also extensions, not on the decision to settle the case, but just to look at the way courts or jurisdiction are organized, considering, for instance, appointment of judges, the role of juries in civil court litigation, punitive damages, or class actions. I will not develop these points because it's quite technical, but we have clear conclusion about the economic effect of this organization dimension. Please, the next slide. So, just to complete this first generation of models, litigation expenditures has been studied on another perspective. The intuition is quite simple. This is just to observe that maybe the probability, or if you prefer, the outcome of a trial could be determined by the amount of expenditures you could invest in the case. This is a specific categories of game defined as rent-seeking games. And particularly these games have been used to compare adversarial versus inquisitorial procedures. I don't really like to use this terminology in civil procedure, so I prefer to speak about active versus passive judges. This is my own terminology. I'm not sure it is always relevant, but the intuition is quite simple. Active judge is very, the active judge manages the case about the discussion with experts, etc., etc. Passive judge, it means that the litigants themselves play the more active role during the proceedings. And the debate is interesting, particularly if you concentrate on the debate between Posner and Tulloch on this topic. And there is a terrific paper by Tulloch, Gordon Tulloch, a very famous economist. The title of the paper is Defending Napoleonic Code. It's quite infrequent to have an American economist who want to defend the Napoleonic Code. That's quite interesting to note this observation. So let me just explain, give you the intuition. In the preliminary paper by Posner in 1973, Posner argued that adversarial system is better because it allows parties to bear the cost and benefits of the trial to manage the proceedings. That's quite intuitive. Now, a few years after, Tulloch said, no, Richard Posner is wrong. Adversarial proceeding is dangerous because it encourages parties to spend too much. There is a waste of resources to convince the courts. Of course, it was a debate in the American system, but it is quite interesting for all the legal systems. The example, I just give you an example of that, my interpretation of the Tulloch paper. Suppose you have an active judge that use, for instance, this is a very high level, 80% of the total resources that are invested in a case to conduct investigation. And each party just uses 10% to present its case. It's quite clear that you can say 90% of the resources committed to the trial are used to tell the truth, to find the truth. Conversely, if the judge is more passive and you change the allocation, 10% of the resource, while each party is using now 45%, you will observe, following Tulloch reasoning, that 55% of the resources will be used to reveal the truth. So it means that nearly half of the total amount will be used to mislead the court. Okay, maybe the word are strong, but it is the intuition. So it means that inquisitorial type of procedure would be more effective to allocate resources to reveal the truth about the circumstances of a dispute. I think this debate between Tulloch and Posner is probably one of the most interesting questions about the comparison, for instance, between common law and civil law systems. So next slide, please, Nicole. A last categories of researchers on procedural law and economics is about evidentiary rules. I will not develop anymore in details, but we concentrate on, first of all, on standard of proof. I mean, preponderance of evidence, clear and convincing evidence beyond reasonable doubt, to compare, for instance, common law and civil law systems. We know that for civil liability, for instance, in the US civil law system, we refer quite frequently to preponderance of evidence. It means that you just impose to the court that the probability that an evidence or a fact is true is higher than it is false. So in probability term, it means that you need to have a credibility of 50%. When you look at the other systems, like the French system, it is not so clear because standards of proof are not exactly the way we refer to evidentiary rules. But I've done the job a few years ago looking at the jurisprudence of the Cour de Cassation in France to look at the probability level. And it is not 50%, definitely not. When I find sometimes probability numbers, it was about 85 or even 90%. So it is quite interesting to consider these evidentiary rules from an economic perspective, to discuss, for instance, the burden of proof between the parties, to look at the possibility to have exclusion rules, for instance, considering statistical inferences. This is particularly important today if you refer to jurymetry or predictive justice. I think this kind of researchers could be very useful to consider the new perspective with digital procedures. But for now, the most significant researches have been expressed about the question between the trade-off between efficiency and risk of errors. If you admit that the goal of any legal system is to be effective, efficient, and to limit the risk of error, what can we say as economists on this question? If you consider errors, you can observe two types of error. Type 1, innocent people or innocent defendant will be declared liable. And type 2, when guilty people will escape liability, for instance. Just observe that if you consider, for instance, preponderance of evidence, it symmetrically distributes the risk of errors between the two parties. The two risks are identical from a social perspective. So if you look at society, considering that the two types of errors are identical, you will say preponderance of evidence is a good way to develop evidentiary system. Now, if you consider that maybe type 1 is more significant than type 2 errors from the society, you will have to change the standard of proof. You can also calculate the optimal standard of proof when you seek to minimize the occurrence of errors, for instance. And that's also another way to discuss this question as economists. You can observe, this is my colleague Dominique de Mougin and Claude Fruet, a very good expert on that question, that show that preponderance of evidence is better when you are looking for preventions, for care level, for liability case, for instance. But as soon as you consider that society is averse to the risk of errors, typically preponderance of evidence is not the best way to conciliate efficiency and the risk of errors. So there are many, not so many, but there are significant research on that question. I apologize to be very short on this, but I cannot develop everything. I hope it will be more complete in the paper I will send to Enrique in a few months. So please, Nicole, the next slide. Now, please, for the second part of this presentation, I will be brief, but I just want to motivate the CPLJ program with the macroeconomic dimension. It is mainly based on empirical studies now, not on theoretical models. The point is that law matters. As law and economic scholar, Loic just spoke about the book 20 years ago on the law and economics in civil law countries. Yes, there are now a very active research field in law and economics all around the world. And it is not only in common law countries like in the very beginning of the modern history of law and economics. For instance, considering law and finance. Law and finance that has been developed just to explain for how law matters. Law matters because, for instance, at the macroeconomic level, growth depends on investment. Investment depends on the investors. And the decision to invest by investors depends probably, as shareholders, on the quality of the rules that could protect investors. That's quite intuitive. Now, at the very beginning of this program, everything has been concentrated on the substantive rules. This is a very recent tendency to look at the procedural rules. now, if you look at the most significant program in this domain, I mean, for instance, the Doing Business program of the World Bank, trying to rank countries according to their legal origins, you can observe there are some perspective about procedural rules, but it is a very basic vision of procedural rules. I mean, formalism, the number of procedures you have to satisfy before to be able to create a business or to solve a conflict, commercial conflict, for instance. This is, in my opinion, too simplistic when you speak about procedural systems. It is too simplistic, and maybe it is even not relevant because it is always considering the basics of common law and civil law system. In my opinion, more and more systems are hybrid, and we observe convergence between legal systems. So it seems to me that we need to improve the way we want to evaluate the impact of procedural rules. And more recently, that's typically what I observe in the literature. Probably that's also interesting to note that the improvement of the research today is also connected to the impressive development of databases, on legal databases, by the World Bank, by the OECD, by the IMF, by the CPLJ and the European Council level. We can now improve our evaluation of procedural principles, like, for instance, fundamental procedural guarantees, judicial independence, impartiality, some other principles like jurisdiction rules or judicial management of proceedings. And this is typically the objective of legal indicators. I will not develop in details the way we can develop indicators, but we have today indicators about the rule of law, about the legal environment, about legal certainty. So I would like just to give you some ideas on that point. So next slide, please, Nicole. Just an example with a recent report by the European Union, just looking at the impact of cross-border litigation on the strategies of companies, of firms. This is very simple. I just take two pictures. One is about the first question in this report: do the current differences in national civil procedural rules constitute a barrier to trade? This is very simple. Observe that immediately you show that more than 50% consider that it is a barrier or even a strong barrier. And you just look at the cost of civil procedure. You can imagine when you are a small company or even a medium company in France, even in Alsace, and you want to sell your product or your services in Germany, of course, we can easily understand that the way you cannot, even if you understand the content of the law, the substance of the law, it is not so easy to enter a market if you think that procedure is unclear. So on this observation, based on this observation, next slide. Thank you. There are some research by economists who try to show that even if you have perfectly integrated and similar countries, legal procedures could differ, and that legal cost could be higher when business is done abroad. That's a very simple observation, but it means that we have what economists define as home bias. And just to give you an idea about the evaluation suggested by some economic papers on that topic, at the European Union or OECD countries level, the estimation is about potential to improve trade between European Union countries about 25%. So it means that we consider that 25% of trades are not observed because of difference between legal procedures. This is, of course, something we can discuss, but it is a type of economic impact of legal procedures you can observe in the literature. Next slide. Thank you. So now I would like to finish my presentation with a more general discussion about legal indicators. Considering that law matters, considering that we have economic impact of differences between legal procedures, it could be useful to have a cartography of legal particularities or legal characteristics. This is an example. This is an original work that I've done for the Fondation pour le droit continental in Paris. That's a program we have in my research center. We try to collect all the big data around the world about legal indicators. We have thousands and thousands of data collected from private as well as public organizations. And we use this data to build an original cartography. I just give you a few examples using here the World Bank data on the rule of law. And we just, there is no ranking. The chart is not, the map here is not interactive, unfortunately, because I cannot go to the website. But if you go to the website, you will be able to zoom on different parts of the world and to have specific information about all the indicators. So next slide, please, Nicole. This is another example with the Global Right Index using the same colors. This is to have a visualization of the legal indicators. So next slide, legal environment. This is produced by a private organization. Just to, I will not develop the exact content. You will, if you are interested, I can give you all the information about the, of course, the calculus of the characteristics for each country. So next slide. This is a final one. This is the most recent. I just finished this map a few days ago. It is an attempt to take all the data available. So here it is a consolidation. This is I put together all the indicators I can collect using private as well as public law information, and to have aggregated indicators about the quality of law. And it is, I hope, useful to have this kind of information for scholars as well as for public decision makers. Next slide. Just to give you an example about what we can do using this type of information of data. This is another index that I have built. This is a legal certainty index. Just to give you an idea, it is an index that captures different dimensions: predictability, stability, and accessibility of any legal order. It is an original data set because I collect information in 20 countries only, because of course I'm not able to compete with the World Bank to collect information. The cases are built with legal scholars, only experts, and we collect a lot of information, considering that from an economic perspective, the legal certainty constitutes an essential asset for society, for economics. So I don't want to develop the way we built indicators, but just to give you the interest to have such indicators. I make, especially for you, a few calculus just to show you the relevance of this type of index referring to procedural rules on economic indicators. Next slide, Nicole, thank you. This is just to give you the correlation between legal certainty and GDP. The fact that the line is increasing, this is the slope is positive, means that there is a significant impact of legal certainty on the GDP. Next slide. The same thing, legal certainty has a positive impact on the effectiveness of government. Of course, I have to confess that it is a modest result because I have only 20 countries. So, you know, even if you are not statisticians, you know that this degree of significance in a correlation depends on the number of points you have. 20 is low, but it is nevertheless significant. I would be happy to have more countries, but unfortunately, I don't have all the data for all the countries I would like to consider. Next slide, Nicole. This is about control of corruption, legal certainty, if you prefer, accessibility, previsibility, stability of law, as something to do with the control of corruption. And the last one, please, rule of law. This is also positive and significant. So I hope, if you are not definitely convinced by the interest of interaction between law and economics, that we have at least some preliminary evidence, preliminary elements of proof about the importance of legal procedures for society in general and for economic organization particularly. So the very last slide, my conclusion, just to say that from a legal perspective, as I already explained, referring, for instance, to the World Bank doing business program, many people argue that procedural formalism is bad for economic efficiency because it will foster rent-seeking, corruption. This is not so clear. In fact, there are many procedural rules that could foster economic growth. The design of legal procedures is important. It could improve the predictability of court decision. It could, in fact, help to have more transaction and higher investment levels, for instance. A very nice paper by my colleague Ayo and Stefan Voigt in Hamburg have investigated the effect of economic growth for 15 judicial procedures. And he proposed a growth model, and he find in this empirical work that with 67 countries that timeless written and procedural rules have a positive effect on growth. This is the way we can definitely cooperate between lawyers and economists. And it is a way to complete what I introduced first about the classical view of law and economics. And of course, the story is not finished. There are many research. I said future research. This is not exact. This is recent research that are in progress about the digitalization of judicial procedures to see how digitalization can also improve efficiency from an economic perspective. I thank you very much for your attention.
Thank you so much, Bruno, for your stimulating presentation, which gives a complete picture of the relationship between a comparative procedural law and economics. Your insights regarding the macro analysis are particularly interesting, with the use of empirical studies that allows to challenge certain received ideas, especially about procedural formalism. You began your presentation quoting Tocqueville. I will add earring, sworn enemy of arbitrariness, form is the twin sister of freedom. In your concluding remarks, you mentioned ongoing researches on digitalization of judicial proceedings. Digitalization is often seen as a deformalization. I'm not sure this assimilation is relevant, but maybe it leads to wonder how the economist may assess this evolution from the point of view of the economic attractiveness of procedural systems versus legal certainty. What is your opinion on that point?
This is a very relevant question. I have not necessarily a global answer to this question, but I just want to refer to a very recent research program we had between my group in Paris and the commercial court in Paris. I'm more an expert in commercial disputes than in some other fields, but for now, the commercial court in Paris, this is Paris Place de Droit, is trying to develop some digital procedures. And of course, the pandemic or COVID-19 definitely creates strong incentive to move in this way. It is very interesting to discuss with the judges in the commercial court in Paris, and we have also discussion with other people in New York and in Singapore during the last few weeks. This is the same tendency everywhere. Digital court, digital desk for judge, digital signature, identity, etc., etc. So definitely, this is a kind of deformalization that could constitute a facilitation. So you could reduce what we define as economists as transaction cost. Okay, good. But what is really interesting is to observe that the appropriation of these tools, of the digitalization by the legal actors is not so easy. For now, my main observation is that there are many obstacles for this facilitation, procedural digitalization. Why? I see at least three obstacles. One is about the orality. The languages is not the same. When you refer to the digitalization, when you move from this classical orality in the procedure towards more digital procedural system, there is a change in the information transmission. And this is definitely an obstacle. I will give you the percentage of cases at the commercial court in Paris that are used, that refer to this digitalization. Second, there is also some problem of access, of security. When I speak about accessibility, it is a big question. Accessibility has to be improved. And last, not least, the symbolic aspect of the procedures cannot be ignored when you move towards digitalization and deformalization. Now, just to give you the number, for now, the instruments, the digital tools used by the commercial court in Paris is very, very efficient, potentially, but it is less than 5% of cases that go through the digital court system, less than 5%. So as an economist, I will tell you that from the technological point of view, this is perfectly fine, but from the sociological perspective, we still have to improve the behavior of legal actors.
Well, thank you, Bruno, for your answer. And now I open the discussion for 20 minutes. Margaret, you want to put a question?
Yes, thank you, Bruno, so much. This is probably one of the most comprehensive presentation of the law and economics field, and I learned a lot from it. I just have two simple questions. One is that from looking, it has always occurred to me that law and economics and this focus on accuracy might really reflect difference in how the different legal systems view truth. In other words, if you believe in an objective truth, then yes, the economics aspect would really, you want to weigh it against accuracy. But if you only, I believe, as in the adversarial system, believe in a legal truth rather than an objective truth, then it may not necessarily, the economic considerations might not come out in the same balance. So that's the first question. And then the second one is, in the macroeconomics kind of collection of data, and the conclusion is that predictability aids economic development. And I certainly don't disagree with that. China certainly has, and a lot of countries have developed legal models, legal system, just to kind of increase trade and help their economic development. But I was just wondering whether there's a Marxist layer in there that the field is not acknowledging. And that is that the idea that, in fact, the predictability is there, but the predictability is created by a class structure and benefit is only a certain structure. And so I'm just wondering if you could kind of comment on that as well. So two questions: legal truth versus objective truth in the field of law and economics, and really the Marxist perspective on predictability.
Yeah, thank you very much, Margaret. Yeah, I suppose that the best way to answer to your question about the truth with S, there are different. This is a philosophical question, in my opinion. When you ask me to think about this point, I have in mind the paper, the very famous and very nice paper by Guido Calabresi and Douglas Melamed, One View from the Cathedral. I recommend this paper. This is a terrific paper in 1972, if I'm correct. The paper, the view from the cathedral, let me explain. The cathedral refers to the famous series of pictures of the Cathedral de Rouen in France by the very famous painter Edouard Manet. Manet paint the cathedral maybe 30 or 35 pictures or paintings of the cathedral. But this is always the same object, but you look at the cathedral from a different perspective. This is my answer. In my opinion, yes, we can try to define some objective truth. Yes, that's typically what economists are doing. Like Posner. I'm not Posnerian, definitely not. but I understand what he is doing. There is a kind of absolute truth based on technically speaking, this is a Kaldor-X criterion, and you refer to this criterion to say, okay, the good way is this one because you maximize the Kaldor-X criterion. Okay, this is one view from the cathedral. The point is that it is definitely not the only one. I'm writing for now a book. This is a book not on economics and law. This is on mathematics and law. This is another way. As I explained, my opinion on that is that just the biggest problem in law for legal scholars is interpretation, if you prefer, the meaning of legal norms. What is the meaning of a norm? This is the same question in Paris or in New York or in Beijing. This is the same thing everywhere. So you can say, okay, I'm a positivist guy, like in Paris. I have my toolbox as a jurist. It is enough. I don't need anything else. I have my own subjectivity. And to be clear, I prefer a conscious subjectivity than a false objectivity. That's definitely clear. So now you have different ways to interpret norms. One is legal syllogism. Another is law and economics. Another is law and mathematics, using, for instance, algorithms. This is very impressive to observe what is coming now. Another is maybe imagination with law and literature. So my point is that there is no absolute truth. Even as an economist, I'm convinced that I cannot limit myself to the Kaldor-X criteria. First. Second, about predictability, I will be very brief on that. In my opinion, there is not only one way to reach the same level of predictability. This is a very nice observation by Danny Roderick. When the World Bank began to work on the question of the quality of legal origins and saying, okay, the American US system is more market friendly. And Roderick said, okay, look at China. For investors, this is the top of the top. And this is definitely not the same characteristics as the US law system. So this is in a way the same type of answer on my side. There is no, we have to consider some past dependency. There are past dependents in Europe, in the US, in China, and every system can obtain very good performance from an economic point of view, referring to different legal design.
Thank you, Bruno. I turn now to Rick. Hello, Rick.
Hello, Loic. Thank you very much for this presentation. I'm going to be much less ambitious than Margaret and reflect on recent events, and I'm wondering if you can offer some thoughts about how law and economics, probably microeconomics, would assist in interpreting or understanding them. And I'm thinking about the COVID pandemic. Bart Krans and on an island recently put out a collection of responses to the pandemic in civil justice in almost 24 almost 24 countries. They were very similar in different places, not identical. Here in the US, the question is whether there will be a new normal and what it will be. People have been doing things very differently, perhaps more economically over the last year and a half. Maybe they'll keep doing some of those things. I guess my question to you is, where you have a shock to the system that may very well produce changes in procedures, How, in terms of law and economics, should we go about evaluating that possibility? And when can we do it, since it's not clear what things will be like a year and a half from now? We just know the last year and a half has been different from anything we've experienced before.
Thank you.
This is not the same question as Margaret, but the ambition is significant. When you ask me the consequences of pandemic shock and the way the civil justice will perform, and particularly about civil procedure, I cannot answer from the same as before, from a global perspective, just looking at the French system. I was talking about a commercial dispute a few minutes ago, considering commercial court in Paris. What I observed, that's the intensity of the need to develop mediation, to develop alternative dispute resolution. And in my opinion, it refers also to some procedural aspects. It's, in my opinion, one of the most significant evolution we will observe in the next few months, and it is already the case. And it will constitute an accelerator to develop new ways to solve conflict on the spectrum of possibilities concerning dispute resolution mechanisms. That's my opinion. And of course, also another acceleration is about digitalization and deformalization, as Loic suggested before.
Thank you. Some more comments or question? Nobody? Are you all convinced?
They are thinking about the fact they are convinced or not.
Ich denke, dass Athanasios hatte sich gemeldet. Athanasios would like to speak.
Thank you very much. Well, first of all, I would like to make a comment regarding the digitalization. According to my opinion, there is no doubt that everything which could be digitalized, that this will be digitalized. So we will have, in any case, digitalization in the courts. But this is not the problem. This is not the problem. We have to see what kind of digitalization we will have. The big question is this digitalization a disruptive technology or not? This is the question. Otherwise, we help the judge, we help the court, we help everything with modern methods. But if we have disruptive technologies, we abolish the judge, we abolish the system, we abolish the civil procedure. We make something instead of the civil procedure. This is the big problem in my mind. The second remark, which I would like to do, of course, this is an excellent approach, which we would like to do to work on the relationship between law and mathematics. Of course, you know the oldest, not oldest, the older book of Pellerman, which is, of course, law and logic, but a big part of this is law and mathematics. So I think you are on the right way, and I'm waiting for your book with great pleasure. Thank you very much.
Thank you very much. Thank you very much for your comment. Yeah, you know, Perelman and many other scholars have been interested in the recent period by law and mathematics. But what is really impressed just history you know that particularly in France, for many, some centuries ago, mathematics was not a job. It was not a job, and many mathematicians were lawyers. And we spoke at the time of mathematician lawyers. It was very, very interesting. I refer to Condorcet, to Laplace in France, and etc. There are so many mathematicians who propose a solution for lawyers. And what is really fascinating is that during that period, it was definitely difficult for most lawyer judges to appropriate this method. And maybe we have a new era now, considering the digitalization. But just to agree with you, the point is, of course, not to abolish the judge. That's the contrary. That's my view, is that we need precisely to defend the role of the judge, and to do that we need to educate people. This is my view, and the reason, the purpose of the book will be to convince lawyers and judges, etc., and even legal professors, law professors, to understand what is the challenge to combine law and mathematics. It could be definitely useful. There is a very famous legal scholar in France, Mireille Delmas-Marty, who published some papers maybe 20 years ago with the mathematicians, and it was really impressive. And it is a good way, but unfortunately, I suppose that most legal scholars never read Delmas-Marty on these topics. But maybe we can try to improve the discussion between lawyers and mathematicians. Thank you very much.
Thank you, Bruno, for this refreshing answer about the role of the judge. Three more comments or questions. First, Gilles Cuniberti. Secondly, Burkhard Hess, and thirdly, Remo Caponi. Gilles.
Thank you. So thank you very much, Bruno, for this very interesting presentation. I would like to ask a question concerned with the tension between fairness and efficiency. So that's a debate which has been going on for a long time in the US. And so, as you perfectly know, of course, leading scholars from Harvard have argued that there cannot be any tension, that efficiency is always in favor of fairness. And so I was wondering what was your stance on this, because I think it's very important in the context of civil procedure. At which point should we take into account efficiency? At which point should we decide that fairness matters more? Is there ever a tension between the two? And if none, why? And if there is a tension, how should we resolve this tension?
This is there are many questions in the same with the same idea, general idea. In my opinion, the question of fairness, inequalities in general, has been ignored by law and economics scholars. Why? Because Posner and some other prominent legal scholars, law and economics scholars, like Stephen Schavel or Mitch Polinsky, published in the 80s some papers just to say that, okay, law is not concerned by fairness. That's first of all a question of taxation. From an economic point of view, if you want to you know, in economics, we have two famous theorems. The first is about allocation, efficiency, and the second is about fairness. And the question, considering fairness, is taxation. Taxation. Just consider Thomas Piketty, success. This is a question of taxation. Okay. Of course, taxation could be connected to law, but it is not the point. Now, this is false. This is not correct. Mitch Polinsky and Stephen Chavel's paper is not convincing, in my opinion. And I have a PhD student that is working today on the fairness and the law, inequalities and the law, and we observe from a macroeconomic perspective with a lot of statistics. When you take the Gini coefficient, for instance, and you make correlation with legal origins, this is very clear. The way legal systems solve the trade-off between efficiency and fairness is not. At this, you have different equilibrium. Definitely, on the US side, the question of fairness is not ignored, but it is not at the same levels as in European countries. And if you look at the European countries, you will observe that the north of Europe has not the same characteristics as the south, for instance. So we have very interesting result on that. You will have, Jill, I will send you some interesting papers in the near future because this is very, very interesting. And in my opinion, this is the last part of my answer. I'm not sure that there is a clear trade-off. I'm not sure that we need to make necessarily an opposition between fairness and efficiency. What is really fascinating is that we observe that in some circumstances, we could perfectly align consideration of fairness and consideration of efficiency. This is, I think that the false debate is to have a systematic opposition between both. This is not correct. In my opinion, as legal scholars, you are most of the time interested by both questions. And the fact you concentrate on some of them, this is the Posnerian problem. Just to consider that efficiency is the only question to solve, and considering that efficiency is in a way synonymous as fairness, because according to Posner, the fact to waste resources is unfair. So fairness is efficiency. This is not correct. This is definitely not correct. This is not, at least my opinion. And there are many interesting research to develop on that topic. Thank you for the question.
Thank you. Thank you. Thank you, Gilles, for your question, Bruno, for your answer that I completely agree. We are going to finish with Burkhard first and Remo afterwards. Burkhard.
Well, thank you very much for this very inspiring and informative presentation. I would like to go back to your approach of macroeconomics and the cartography you showed to us. And what I learned was you are comparing, or you are using indicators as a basis of comparison. And I was wondering, how do you collect the data? And because the categories are quite broad, like quality of law, global rights, legal environment. So maybe you could explain this a little bit.
Of course. For this, for the cartography I introduced, I give you just a short, some very simple pictures. But of course, behind that, you have a lot of data. So for these pictures, the data are available data. They are produced by international organizations for this, excepted for the legal certainty index. For legal certainty index, I collect the data myself. So there are different origins of data, of collection of data. It is, to be honest, it is quite simple to obtain data. Some of them are you have to pay, but most of the time they are public data. So we obtain them from the World Bank for some different organization. when I consider the legal certainty index, it's different. For this data, we built cases, legal cases, working with experts in many different domains. And we sent data to legal experts. I never asked to public or civil servant to answer to this question, because we have too big bias, too important bias. We tried to do that, for instance, with China. It was terrible because we obtained always the best score. It was not real. Now we try to collect data, and this is the case for most of data we use for the cartography. They are collected via most of the time lawyers or notaries, for instance, and not only from the country. We prefer to have answers from lawyers outside from the country. So all these data are, to answer clearly, subjective data most of the time, because they are based on the perception of the legal environment by economic or legal actors. That's the only way to work on these questions. Because if you look for objective data, you will limit yourself to the timing of procedures, the number of procedures. Okay, you can use them, but you capture not the very basic characteristics of procedures. That's exactly what the World Bank Doing Business program is doing. This is not satisfying.
Thank you. Thank you, Burkhard. Thank you, Bruno. This is a crucial point, of course. The last but not the least, Remo.
Yeah, thank you, Loic. Thank you, Bruno. I just wanted to come back to the liaison between law and math and the mathematics. It was a very well put point in my view. You know, using mathematics in social science is a general hallmark of modernity. And it was, as all know, a reaction against the Aristotelian practical philosophy. Thomas Hobbes grounded politics on mathematics. William Petty, as you know, Bruno, grounded economics on mathematics, and Spinoza grounded ethics on mathematics, and in Germany, Leibniz grounded law on mathematics. And now I'm not sure if we have to exaggerate now this trend towards using mathematics in civil procedure. I mean, it's in my view, maybe I'm a conservative, but we have to distinguish. I'm talking mainly to my fellow scholar in civil procedure. We ought to distinguish dispute. Only very easy dispute can be solved using, in my view, maybe mathematics and algorithms. In the very important dispute, my point of view, we should come back to the Aristotelian approach, the Aristotelian phronesis, instead of using a mathematical approach. I have no time to develop this point further, but this is only my little contribution to the discussion. Thank you, Bruno. It was very interesting, and distinguishing also the micro and macro macroeconomic approach. It was a very
Thank you.
Thank you.
Thank
Well,
you very much. Yeah, just to answer briefly, I'm not sure that conservatism is not a problem in my opinion. We can I suppose we can conciliate conservatism and at least some modern view about the discussion between law and mathematics. There are two points in what have been expressed. One is about the logic, the use of mathematical reasoning. This is a very specific question. We already discussed about that. The other point, this is a very simple observation. Think about Motulsky, if you know Motulsky, a very famous civil jurist. When Motulsky spoke about evidentiary rules, that's always a question of probability. You cannot escape to probability when you are speaking about the truth from a legal perspective. That's always a question of probability. So my view is that we need to educate people to at least some probability consideration, because it is a reality. This is a life of law to consider this kind of question. So of course, I hope we have the opportunity to discuss of this point in the near future. Thank you very much.
Thank you. Thank you. We come to the end of the discussion. Thank you all for your questions and comments. Thank you again, Bruno, for your presentation and your complementary answers. It was really a very exciting discussion. It's time now to break, but because we are late, we will only have a 10-minute break. Thank you, and see you soon.
Thank you.
Thank you. Let us continue with the second part of the webinar with Remco van Ree's presentation that addresses the use of foreign models of civil national law reform, lessons from history. Remco is very well known in the proceduralist community. Anyway, I will remind that Remco is full professor of European Legal History and Comparative Civil Procedure at Maastricht University since 1998, where he is the director of the program Foundation and Principles of Civil Procedure in Europe of the Jus Commune Research School. He teaches comparative law, civil procedure, history of courts and adjudication, and European legal history in general. But he has a special interest in the harmonization of a civil procedure, both in Europe and on a global scale, and in best practices in this field. Remco is also a visiting professor in many universities in the world, and he is actively involved as advisor in civil procedure reform projects in Europe, and serves as scientific organizer of major seminars and workshops in this field in Europe as well as in Asia. His scientific production is also very impressive. I'm delighted to give him the floor now.
Thank you very much, Loïc. I'm very pleased and very happy to be able to address this distinguished audience on a topic that I've been looking at for years now. And it's the topic of the role of the historical development of procedural law and its significance in modern law reform. Could I please have the first slide, Mrs. Trouet? There it is. Well, there you see the title of my presentation. And please note that lessons has been put between quotation marks. So we'll have to see if indeed there are any lessons to be learned. I should start by saying that the initiation and also the direction of law reform in actually any given society depends on various factors. And I think that the same is also true for the role of foreign models and foreign experiences in law reform. One first factor is the persons involved in the process, and then especially their capabilities and their beliefs, and I think also their influence in the decision-making process. Another factor, the second one, is the existing procedural system. And that may often give to path dependency. You note that I've listened very carefully to the previous presentation. Path dependency in reform. And that is also true where it concerns the use of certain foreign procedural examples. The third factor is, I think, the larger, let us say, legal and societal framework in which the procedure has to function, and which I think to a certain extent determines the foreign procedural elements that are useful and acceptable in law reform, in national law reform. Now, there may be other factors too, but today I will limit myself to these three factors. And I will provide some examples without trying to be exhaustive. I will, of course, write a paper about this, and that paper will address many more developments. But today, since I have only 30 minutes for my presentation, I have to be short. I think that the 19th century is especially important for our topic because I feel that it witnessed important legislative initiatives in the field of procedural law, and these initiatives form part of the foundations of the current procedural relationships among systems in Europe and maybe even beyond. Now, since I have discussed the reform of Austrian civil procedure at the end of the 19th century elsewhere, I will today concentrate on other examples, maybe examples that are not so much known to you. But of course, it should be remembered that Austria is very important, and especially in the 20th century, Austria started to show us the way ahead. Could I have the next slide, please? Now, we go back to the 19th century, my favorite century, I can confess. The 19th century witnessed, of course, the introduction of the Code de procédure civile in France in 1806, but also in the territories which at that time formed part of the French Empire. And now this meant that the French Code would become the law of the land in considerable parts of Europe, including, as we know, parts of Germany, and then I'm talking about the left bank of the Rhine River, which at that time formed part of the French Empire. It was present in Italy, Poland, Belgium, the Netherlands, and so on and so on. But already at the time when this code was introduced, it was clear that the quality of it was questionable, and that is to say the least. Because in many respects, the French code was not very modern, not modern at all, especially at the level of individual rules and legal concepts. Because the drafters, they had derived much materials from a first attempt to create one procedural model for the whole of the French kingdom. And that is the Royal Ordinance of Louis XIV, which dates from 1667. Our French colleagues will be very familiar, I think, with that ordinance. It was drafted under the guidance of the gentleman you see on the slide, Jean-Baptiste Colbert, who functioned also as a kind of Minister of Justice under Louis XIV. But it should be remembered that many rules and concepts were even older, since much of what we find in this ordinance from the 17th century, was derived from the traditional sources of French procedural law. Now, obviously, the code, the 1806 French code, had tried to address some of the existing procedural shortcomings. But all in all, it was a very traditional kind of document. However, what was new about the 1806 code, and that I think explains its success outside of France, was its relatively, but I say relatively, systematic nature, and also its aim of providing an exhaustive set of rules for all of the courts within the French Empire. And so the code was the starting point and the end of any reasoning in the area of civil procedure. And that was new. So this exhaustive nature of the code was attractive, also when compared to the 1667 ordinance, because that ordinance had left much areas of procedure to the initiative of the individual courts within the French kingdom. And this, of course, had given rise to a multitude of local procedural styles, as they call them at the time, stilus curiae. So even though this 17th century ordinance had tried to make litigation in France uniform, it had not touched upon all matters, it was not exhaustive, and therefore local differences remained. And that is something which the 1806 code tried to combat, and that was done, I think, very successfully. So that's what made it such an interesting document. The code was at the time also modern because it emphasized the leading role of the parties in a civil lawsuit. And when you read the code, you encounter times and times again the expression la partie la plus diligente, and so the most diligent party. And the code says time and time again, the most diligent party now takes the next procedural step. The judge, well, the judge is not in view, I think, so much in this code. But that idea, that adversarial idea, was very modern at the time. The French code also underlined the oral nature of litigation. Orality was very prominent. And indeed, in Europe, orality was felt to be one of the central assets of the French procedural code. That was popular in the 19th century. Problematic aspects of the code, however, were related to what Sir Jack Jacob, I think we all remember him, called the three-headed hydra of civil litigation in a wonderful book that he published in 1987 called The Fabric of English Civil Justice. And that hydra, was difficult to combat also for the French in their 1806 code. So excessive costs, delay, and complexity, that's what we're talking about. And these evils, so to say, were especially discussed outside of France in the 19th century, in the various jurisdictions that had adopted French procedural law, either by keeping the Code de Procédure Civile as their national law after the defeat of Napoleon. Belgium is a good example of such a country, or by developing a national procedural model that relied heavily on the French model. My own country, the Netherlands, is an example of such a jurisdiction. Could I please have the next slide, Nicole? Now in France, let us have a look at France first. In France itself, little activity could be discerned to combat the evils I just mentioned, even though it must be admitted that eminent French law professors in the 19th century identified shortcomings and they even suggested changes. However, the French lawmaker remained relatively passive. In 1862, a reform commission was instituted by the Ministry of Justice, but as the eminent Belgian law reformer Albéric Allard, we should remember his name, Albéric Allard, mentioned in 1869, he mentioned cette commission travaille lentement, and that was an understatement, I think. The commission was very slow in progressing. It's also telling that the prominent Paris law professor, Ernest Désiré Glasson, and he was a specialist in civil procedure and in legal history, was actually very mild about the 1806 code in his famous treatise, Les sources de la procédure civile française, which he published in 1882. So at the end of the 19th century, Glasson was very, very positive. In this work, he discusses, as the title obviously indicates, the sources of French civil procedure. And Glasson identifies various historic links in his book, especially between English civil procedure and French civil procedure. And he points to Normandy, obviously, for the origins of these similarities. He also mentions links between French civil procedure and the German lands. Glasson emphasizes the very passive role of the French judge in civil matters. He says, well, our judges are very passive. And he even comes to the conclusion that even the English judges and the German judges are much more active. However, and that is, I think, a little bit sad, he does not evaluate the pros and cons of this difference. No attention, no discussion whatsoever. The author, Glasson, mainly chooses to praise cette procédure vraiment française, and he extols French procedural law by proclaiming the immense superiority of French civil procedure over English procedural law. And on the slide, you find a long quote in which I think he makes it even worse than I've just told you in my translation. Feudal procedure, that's what the English have, and it's obscure, etc., etc., etc. Now, this attitude may explain why, as Alain Wijfels, a law professor from Leuven in Belgium, has stated, that explains why I think during the 19th century, French law remained part of a cultural model which was much more prone to influencing other systems than to observing beneficial procedural influences from abroad. And I think this would only change during the 20th century. And in this century, actually, in the beginning, French procedural lawyers didn't look as much at other European countries, but what they did is also stated by Wijfels in a very nice article, where he states that an important source for comparative approaches in this period were French enactments in the French Empire overseas. And the author states some of these, especially in Morocco and Tunisia, were highly regarded because of their doctrinal foundations and their innovations, which, that was very important, remained rooted in the French tradition. Let us have a look at parts of Europe outside of France. Could I please have the next slide, Nico? Now, outside of France, foreign procedural models were used widely in law reform, and that actually from early in the 19th century onwards. Since many European states had become familiar with the French procedural model during the Napoleonic age, the virtues, and there were many, of course, the virtues of the French code were recognized throughout Europe. But at the same time, one was very clear about its shortcomings. These shortcomings of the code were discussed outside of France, and often a French procedural model was adopted outside of France, in which elements that were considered harmful or negative were removed. A very first example is Geneva, where a new procedural code was drafted by a commission chaired by a professor, and you see his picture on the screen, Professor Pierre-François Belot. And his code was adopted in 1819, and it became the law of the land in Geneva, the canton of Geneva, in 1821. And that code now contained considerable improvements when compared to its French example. It not only adopted French ideas, it not only improved upon French ideas, but it also incorporated elements of procedural law from Geneva itself. As an example, I can mention the structure of the Geneva Code. It improved the structure that had been provided by the French Code, and most of the time it followed the ordinary course of a civil lawsuit. The code also in Geneva provided the possibility for the parties to discuss the opinion of the public ministry. You know that according to the French model, the public ministry may give an opinion in civil lawsuits. In France, there was no possibility for the parties to react to what was being said. But in Geneva, they found that that was very important, an important element of a more adversarial approach to litigation. The code also curtailed preliminary conciliation. Preliminary conciliation is something from the French Revolution, but it was very quickly clear that conciliation in a very early stage of litigation was not very successful because the parties did not know much about their relative positions. So that was being curtailed and at a certain moment even abolished. And we're talking indeed about the beginning of the 19th century. Yeah? In France, it took much longer to get rid of this, this feature of the procedural code. Belleau also increased the powers of the judge in the management of civil cases. For example, judges in Geneva were now in charge of time limits, and they could even order the submission of specific documents, also very, very modern. And what was also interesting is that the Code of Geneva abolished the traditional distinction, traditional is a difficult word, the traditional distinction between summary and ordinary procedure. And what they did was they introduced one uncomplicated procedure fitting almost any case. And so the ordinary procedure in Geneva was modeled upon the summary procedure, and that was the only procedure that was made available by the Code of Geneva. Could I please have the next slide? Now, Geneva really, and it may be surprising because Geneva, of course, is not a very big territory. The Code of Geneva would be the focus of attention in many European countries, and it actually influenced legislation in other countries to a considerable extent, but sometimes after some hesitation. We see a picture here on this slide, and that's a picture of a French-speaking member of Parliament of the newly created Kingdom of the Netherlands. You probably remember that in 1815, present-day Belgium and the Netherlands, and I think also parts of Luxembourg were joined together. New Kingdom of the Netherlands. And the gentleman we see was a member of the Parliament, a French-speaking member. When deliberating about a draft procedural code of the new Kingdom of the Netherlands, this member, Antoine Joseph Barthélemy, he would later become the first Minister of Justice of Belgium after what in the Netherlands sometimes is called the Belgian Revolt of 1830. He felt that many of the Genevan improvements could actually not be used in the Kingdom of the Netherlands. And what was his argument? He said, well, Geneva is too small. It's only a small state. And then he said, well, of course, this would have been different if the Geneva Code would have been destiné au service d'un grand État. But, well, that was not the case. Fortunately, later in the 19th century, this hesitation disappeared. And the example of Geneva would be studied very carefully in various law reform projects, for example, in Belgium, in the Netherlands, but also in the German lens in the context of drafting a civil procedural code for Hanover, which of course at the time was an independent state. And through Hanover, it would be very influential, this Genevan example in the drafting of the German ZPO of 1877, the old German civil procedural code from 1877. So Geneva was leading the way, not in France, but outside of France, and especially in parts of Europe that had followed the French example. Let us now return to Belgium. After Belgium became an independent state in 1839, law reform projects that were started within the context of the Kingdom of the Netherlands were discarded. The Belgians didn't like what had happened in the United Kingdom. The French-speaking Belgian aristocracy was predominantly, I think, of the opinion that the French codes should be maintained. They wanted to keep the French codes. And in the area of civil procedure, and that's very surprising, I think, this meant that the native Belgian product had to wait until 1967, so well into the 20th century, when the code judiciaire, het gerechtelijk wetboek, as we call it in Dutch, was introduced. But this did fortunately not mean that attempts to bring Belgian procedure up to modern standards also had to wait until 1967. But it's very shameful, it's actually a shame that the most promising project failed because one of the suggested reforms concerned the abolition of the procurator, the avoué. The Belgians in 1866, at least the drafters of the law reform project, thought, well, the distinction between advocate and procurator, that's expensive. You need to hire 2 lawyers to litigate your case. Let's do away with the procurator. Let's do away with the avoué. That will save costs. That will make litigation cheaper. But that met with very strong and a very successful opposition by the procurators themselves, who were members of the parliament in Belgium. So you can imagine what happened. The project I'm talking about was initiated in 1866 under the guidance of a very promising young lawyer, a young man, and he was also a law professor at Ghent University. I already mentioned him, Albéric Allard. Maybe I can have the next slide. We can see him on the next slide. His project was truly comparative in nature, and it really shows that Allard was knowledgeable about many of the procedural systems of his time. In his report, which is, I think, still very interesting reading material for modern lawyers, he states, and you see it in French on the slide, I've tried to translate it, next to the various French authors who wrote about procedural law reform, comes another rich mine to exploit: comparative legislation. Comparative legislation, that had his interest. And we should, of course, realize that comparative legislation is different from comparative law. Comparative legislation does not look at the law in practice. But indeed, that was what Allard was doing. He was comparing the various legislations in the world at large. He then continues, also in French, and I've tried to translate again. Undoubtedly, he says, this study requires a lot of discernment. We must not seek lessons from peoples whose judicial institutions differ significantly from ours. But the imperial code, and he means the Napoleonic Code, was in force in several countries where it was later revised. And these new laws, these revisions of the Napoleonic Code, can, on certain matters, serve as a model for us. In all, they provide many points of support for the reforms that need to be introduced into the procedural system. And in this context, our author refers to the procedural systems of the Netherlands, of Geneva, and he also discusses in great depth the new procedural legislation for the Kingdom, the United Kingdom of Italy, which came into being in 1865. France, well, that's not interesting according to Allard, since at the time he is writing, 1866, the country has brought about, he says, few reforms, and these are, in the opinion of the learned author, assez médiocre. I hope I pronounced that correctly. Especially Geneva and Italy are worthwhile, according to the Belgian law professor. In his footnotes, by the way, he refers to a large number of foreign legislations, also North American ones. He refers to legislation for various colonial parts, colonies at the time. It's a very rich report he writes. He knows about many developments in the world at large. He also mentions that the former codes of the various Italian principalities are interesting source material. He says, well, you should look at that. And Allard, of course, would know this at first hand, since he was the author of an examen du Code de procédure du Royaume d'Italie, an examen du Code de procédure du Royaume d'Italie. I try to rehearse my French, a study which was later translated into Italian and for which Allard received the Ordine della Corona d'Italia. Could I have the next slide, please? So what did our friend Albéric Allard suggest? Well, according to its drafter, according to Allard, his project, the Belgian project, was structured better than the French code. We see it again. Pierre Belot mentioned it, and now also Allard tells, my project is better structured. The first part of his project was devoted to the ordinary procedure in civil matters, whereas the second part contains specific rules for specific tribunals. The preliminary conciliation attempt of the French code had been abrogated, again like Geneva. The formalities of the summons had been reduced considerably, and time limits, ladies and gentlemen, were much abbreviated. The statements of case were also reduced in number. The statement of claim would be followed by a statement of defense, and the reply to the defense would only be allowed by the judge exceptionally. Powers of the judge were increased. Furthermore, the number of written documents that could be submitted to the court was reduced. The cautio judicatum solvi was abolished, also for foreigners. And so very, very forward-looking, this draft from 1866. The powers of the judge had been increased. He even sometimes followed the model of criminal litigation. So he apparently was in favor of a less adversarial system. And independent appeals against most court orders were not allowed anymore, but had to be brought together with an appeal on the merits. Also something rather modern, I think, something that is still being contested in some European states where they like intermediary appeals. But Allard didn't like this. He said that stops litigation, that slows down the progress of a civil lawsuit. But as I've said, unfortunately, the draft did not become law, not because of its bad quality, but because Allard had probably underestimated the force of the opposition against the abolition of the procurator. And he wanted to do this because he felt that it would be a wonderful improvement from the perspective of costs. But the procurators were very powerful in the Belgian parliament. Could I have the next slide, please? I now take you to Germany. It's a little tour of Europe, Northern Europe. We go to the German lands. In the German lands, comparative legislation, as Allard called it, played an important role in debates about an old German procedural code. We are moving towards the time in which Germany gets united. The leading figure in this context, well, you see him on the screen, was without doubt Gerhard Adolf Wilhelm Leonhard. He was the Minister of Justice first of Hanover and later of Prussia, and he played an important role in law reform in the Kingdom of Hanover and later also in the drafting of the German ZPO. This gentleman was keenly interested in foreign procedural models, and proof of that can be found in a wonderful study, again something that is worth reading again, published in 1865, so before the unification, and that book is called Zur Reform des Zivilprozesses in Deutschland, on the reform of civil procedure in Germany. And in that study, Leonhard discusses the draft of a future unified civil procedure for the German states. And he takes the ZPO of Hanover as his starting point, because he had been involved in drafting that ZPO. And his study is truly comparative in nature. And he refers to various foreign, but also German. German consists, of course, of a series of smaller states, various German examples in his book. And a central question was, to what extent should we use the French example? The French example as we know it from the German Rhineland, left bank of the Rhine. Can that actually serve as a convenient model for an old German ZPO? Now, the author comes to the conclusion that one should use the French model with some caution. One of his more political reasons, I think I can classify them it like that. One of the more political reasons for such an approach is expressed by him as follows. It's the first quote in German on your slide. It would be regrettable if French law would set aside German law, causing German legal scholarship to become part of legal history and of the jurisprudence of France. Well, I think indeed political. A less political reason, which most likely expresses the main concern of the author, is stated as follows. It's the second quote on your screen. It says, it would be deeply regrettable if Germany were not even spared those procedural institutions which are condemned by legal scholarship, by legal practice, and even by legislation in France and in those non-German states sharing their procedural law with France. Can I have the next slide, please? Now, as an example, Leonard mentions the way the French code has regulated the introduction of preliminary defenses or exceptions. For example, an exception as regards to the jurisdiction of the court. And he states, that's a rather funny quote, I think, in dem Titel 9, which is called des exceptions in the French code, in dem Titel 9 ist ein förmliches Verschleppungssystem organisiert. That means something like, well, a formal procrastination system, a formal system of delay has been organized in Title 9 of the French code. Our author is also very critical about the distinction between the ordinary and the summary procedure in the French code. And he refers to the Netherlands, and I'm very happy with that, of course, as an example of a jurisdiction where improvements are attempted by trying to make the summary procedure the standard procedure for the largest number of cases. Now, it seems that Leonard was unable to reach Dutch, which is a shame, but his contacts around Europe allowed him to obtain the necessary information. In a footnote, he states, and the footnotes can be found on the screen again in German, I base this and the following statements on written information which I owe to the great kindness of the Dutch Minister of Justice, Mr. Godefroy. It's a pleasure for Germans to notice how this man, who is highly regarded as a lawyer and who has fully mastered the German language, is actively interested in the achievements of German legal scholarship and legislation. And of course, such an attitude is of course necessary in order to make sure that foreign examples have an influence in law reform. So if even the Minister of Justice, who at the time of course was much more influential as regards law reform than nowadays, even the Minister of Justice is interested in what's happening abroad. Most likely the results will be very interesting, and they were. I come to a conclusion. Obviously, thank you for changing the slide indeed. Obviously, I've only been able to discuss few examples of how the discussion on civil procedure and procedural reform was truly European in many parts of Europe in the 19th century. The discussion was instigated and facilitated by jurists who possess the proper qualifications to conduct it, knowledge of foreign languages, relevant contacts with jurists abroad, sufficient influence at home due to a good political antenna, although Allah probably didn't have that antenna, and a strong interest in reforms in all the systems due to the fact that they recognized that all over Europe the same battle had to be waged, a battle against the proverbial three-headed hydra of Sir Jack Jacob: costs, delay, and complexity. It's always the same story. Now, this approach proved to be easier in jurisdictions that did not serve as a model for other European states, since lawyers in model jurisdictions were prone to conclude that little was to be learned from states that had adopted their model. In the 19th century, such an attitude could be found, for example, in France, even though it must be admitted that in French literature, the vices of the French procedural model were discussed in depth, but not always, actually very rarely, on a comparative basis. These discussions, however, did not result in major law reforms in France throughout the 19th century. And where reforms were introduced, these were often not based on comparative law research, but on something else. Early examples of what you can still qualify maybe slightly as comparative law in French procedural law, it usually not take the example of other European systems as their starting point. But in France, one used the results of experiments in the French colonies as their guiding star. It must be admitted, however, that this approach was not limited to France, but could also be found in other colonial states, such as the Netherlands, where experiments took place in Indonesia, the former Dutch East Indies, in Belgium, where Congo served as a testing ground, and also in the United Kingdom, where major law reforms in procedure were tested in British India. These experiments and their influence on law reform in Europe, I think, deserve further attention, but well, they're outside the limits of my presentation of today. Now, apart from capable law reformers, more is needed to make law reform, and especially the influence of foreign models, a success. The law reformers work within a certain procedural context, within an existing national procedural model, and the usefulness of foreign examples is dependent on what one may call the family relationship of the system in need of reform and the foreign example. Now, in the 19th century, the influence of the French model had become pervasive, even though a lot of criticism was voiced. And therefore, French law could serve as a starting point, a real starting point in law reform in many European states. Often the concepts and ideas in the various European states were similar, even though the particular solutions that were chosen were sometimes different. And of course, this was not only the result of the major role played by the French model in the 19th century, but also due to the basis that most procedural models in Europe found in the historic Romano-canonical procedure. And of course, finally, the wider societal and political context has to be taken into consideration. And I think it seems that in smaller states, one is less scrupulous to take foreign examples as a guiding star than in the bigger ones, since the more politically motivated concerns about looking abroad are not as often voiced in the smaller jurisdictions. I don't encounter them very often, but I encounter them in the bigger states, in Germany, in France, and so on. A good example of a small country where a prevailing interest in comparative law has resulted in a situation where Dutch civil law can now be viewed as a successful marriage of ideas between various European traditions. A good example is the Netherlands. And so when you look at the Netherlands in civil law, you find a very fruitful marriage of ideas in the civil code from various European traditions, whereas in procedural matters, similar developments can be witnessed. Obviously, in civil procedure, the examples in the present Dutch legislation are French and German, but also American, as the current Dutch rules on group settlements and group litigation. I think a topic that the director of the Max Planck Institute likes very much may demonstrate. In 1993, the famous Belgian legal historian, the late Professor Raoul van Kaanegem, who also wrote extensively on the history of procedure, published a book which he called Judges, Legislators, and Professors. Now, this book was based on a series of lectures delivered at Cambridge, and the innovative feature of it was that the author did not follow the traditional path of describing the development of legal ideas. Instead, he tried a new approach by interpreting legal history to a large extent he saw it as the result of a power struggle between various groups in society. My presentation of today may have demonstrated that such a power struggle is also present in the field of procedural law reform. But unfortunately, this does not always result in a situation in which the best ideas prevail, as the failure of the draft law of one of the historic colleagues of Professor van Kaanegem at Ghent University, Alberic Allard, has demonstrated. If history may provide any lesson at all, it could be that in the area of law reform, politics and lobbying often provide stronger arguments than the quality of draft laws. I would like to thank you very much for your attention. Cannot hear you, Loïc. You should turn on the microphone.
Sorry. Good. So many thanks, Remco, for your inspiring presentation, as usual, and the tour d'horizon you have provided about the process of the procedural law reform during the European 19th century. The 20th century is another chapter. Anyway, I think that the states did not easily recognize it, but international sources of their own law are much more important than they appear. The influence was often underground. The history of civil procedure is largely the history of the circulation of ideas and concept, as you said, before being that of rules and techniques. And in this regard, I will put the first question, Remco. I would like to know what perspective the historian of civil procedure has on European construction. Is the emergence of a European procedural law in the continuity of the historical process you describe? Or is it more a paradigm shift in the use of foreign procedural models? I would say 130 years after the masterpiece of Franz Klein, is there room for a European pro futuro?
Thank you, Loïc, for this very interesting question, which is a question which is difficult to answer. What has changed? Well, indeed, that's a good question. What has changed? Obviously, we are working in the context of, for example, the European Law Institute, and we are busy drafting model European rules. Projects like that, in which large groups of scholars come together, scholars from Europe, lawyers from Europe, and which procedure is discussed from a truly European perspective, such projects did not exist in the 19th century. Law reform and the use of foreign models was basically something that happened within the national context. And obviously, that national context that could result in some kind of alignment of procedural systems because countries copied solutions from each other. But the solutions that were being copied, of course, were not always the same. So there was some basic foundation, I think, in the procedural systems of Europe that was alike. But in the end, yeah, it were brothers and sisters, and copying and borrowing from each other did not result in these systems becoming twins. Is it nowadays different? Well, that depends on how much influence you think that European law and European initiatives have. When we look at what has happened within the context of the European Union, of course, we very often see failures. And when we look at the small claims procedure and the order for payment procedure, for example, I think these are not very popular. So in that area, I'm not sure if much development can be noted. And I'm also not sure whether Europe is being inspired by the common traditions of the member states when legislating. When we look at the project of the European Law Institute, that may be different. There we get best practices in the area of civil procedure based on comparative work. But of course, the question is going to be, how is this project going to influence national law reform? Because again, we are talking about national law reform, I think. And I'm not sure what will happen. What I noted when the principles of transnational civil procedure were drafted, initially there was a lot of opposition. And there is this book by, I think, Philippe Fouchard, where many lawyers are very much against it. That changed later on, but the book initially, the book provides the initial point of view. So very difficult to answer. I think we're still working in an environment in which the foundation is similar, but the house built on that foundation still looks very different. But hopefully things will change due to projects like the ELI project.
Thank you.
I hope that answers your question a bit.
No, it was perfect. Thank you, Remco, for your answer. I turn now to the audience, and I see Burkhard first and Rick secondly want to put a question. Burkhard.
Remco, thank you very much for this historical round trip throughout Europe in the 19th century. I would like to ask you one question. which came across to me when I was working a little bit on civil procedural law in Germany in the 19th century. I have a little bit the impression that we have to distinguish a stage before and after the codification. Before the codification, there is curiosity, there is comparative law. But after the codification, there is the interest in applying the new code and to apply it in a systematic way. And there is no room left for, or not much room left for comparative studies. Let me give an example. I wrote an article about Johann Anton Mittermeier, who was a law professor in Heidelberg in the beginning of the 19th century. And he always reported in his journal readings of developments which he found in articles coming from abroad. And he was very, very famous. He passed away in 1867. After his death, he was immediately forgotten. And one might ask why. Well, you have already given the answer. The codification, the Code of Civil Procedure of 1877 in Germany. And what has happened at the same time? Now we have to look at Arthur von Bülow. Arthur von Bülow took up the new procedural science in Germany. He set up the Zeitschrift für Zivilprozessrecht. And if you go to the first volume of it, first article, so he says, we are now in a new time, a new area. We have to be systematic, we have to be dogmatic, we have to apply the new code. And for more than 100 years, with the exception of the Austrian exchange, the Germans remained within their own borders. Really amazing. And of course, there are cultural aspects. And it was also the process of nation building and the codification, which was certainly very much important and also an impediment to comparative perspectives. But this is something which really struck me, and I would like to know your opinion on that. The second part of my question, you have already answered it when you were answering to the question of Loic. Today, I agree, we are in a different situation.
Thank you, Burkhard. Remco.
Thank you, Burkhard. An interesting question. By the way, Mittermeier is also present in the Netherlands. There is one of the first legal journals after the separation of Belgium. And in that journal, Mittermeier always contributes. So we get a lot of international information from him in the Netherlands as well. In German, by the way. Dutch lawyers were able to read German. But then to your question, indeed, that is the case. You're of course right. After the formative period, the windows close, so to say. And I find it interesting that this usually happens in the larger states of Europe, states that are in the process of nation building or that have already built their nation. These states are very inward looking. And we've seen that in France, where one felt that little could be learned from other legal systems. That isn't the case in Germany, and Germany is not united. But as soon as the unification has been brought about, as you rightly state, and when the codification has been introduced, things start to change. In the smaller European states, the windows remain open. I think in Northern Europe, in Scandinavia, in the Netherlands, even in Belgium. And I feel that for that reason, the procedure of those smaller states is so interesting, because there one profits from developments that can be noted in different countries. One does a bit of cherry picking, I think. Something that works in Germany is copied, and then we look at France, and then we look even at England in the Netherlands. And the result is often very, very promising. Usually these systems are very efficient, very cost effective, the quality is high. And I think it's a shame that doesn't happen in the larger European nations, maybe due also to political reasons. When we read, for example, why Leonard did not like the French Code of Civil Procedure so much? Well, the first reason he gives is a political one. We Germans should not become part of French jurisprudence, which is, of course, not a very strong argument if you're trying to improve your legal system. And those arguments are very often absent in the smaller states. We have the Minister of Justice of Belgium, who then still was part of the Dutch Parliament, who says, well, we should not look at Geneva because Geneva is only small. Well, that's maybe a reaction in line with what happens in bigger states. But in smaller states, I feel it's different. I'm not sure if that answers your question, but I can at least agree with your statement about the later developments in Germany. That's true. Yeah.
Thank you, Remco. I turn now to Rick. Rick, you have the floor.
Thank you, Loic, and thank you, Remco. Excellent presentation. I want to look outside Europe, but in the 19th century, and look to Japan. And I'm wondering whether you think it fits what you expect. My understanding is that in Japan, after it was militarily, in essence, forced to open, there was consideration of the procedural rules to be adopted, and at first consideration of the French, maybe the French 1806 code, but eventually, as I understand from Japanese colleagues, instead, Japan opted to model its procedure on the German code, perhaps on the ground that it was modern, and I guess they just missed out on Franz Klein, who had not come on the scene yet. I wonder how you would interpret that. Maybe there were no traditions. It was kind of what we would call a blank slate in Japan, and it's just different from the various European nations, but Japan was choosing among European models, and it picked one. How do you fit that into your analysis?
Well, that's a very interesting question. I can refer to the legal historian I mentioned earlier on, Raoul van Kanegem, a very inspiring Belgian legal historian. And actually, that's the only thing I can mention about it, because I don't read Japanese, so I'm not sure what really happened. But he said, well, during the Meiji period, there was this opening up, as you stated. And originally, they were thinking about introducing French law. The French Civil Code was, for example, very popular in Japan. But then we had Sedan, and then we had the defeat of the French in the Franco-German War. And Van Kanegem said, well, really, that mattered. That mattered. The Japanese thought, well, we're not going to introduce the laws of a state that is defeated. Let us turn to the victors. I'm not sure if this is completely correct, but there is this statute. There was this statute of a professor, Boissenard, I think, a French Paris law professor, civilian, that was in the law faculty in Tokyo. It was removed after the defeat of France. So it can be as easy as that, a very political decision. Of course, Japan is a very interesting example because Japan copied the German model completely. I'm not sure how it was introduced in practice. We don't know much about the practice of civil procedure at the time, but the text was literally translated. And apparently because of these political issues, if I follow the explanation of Professor van Kanegem. The same, of course, happened in China in 1911. After the fall of after the last emperor left, they decided in China to introduce something modern. Well, the modern thing was the German procedural code and the German civil code. And why was that? Well, that was not even for political reason. That was because the Japanese were familiar with it. And apparently, culturally, the distance between Japan and China was less than the distance between Germany and China. So they copied the German model, but based on what they noticed in Japan. There must be more to it. I agree. There's maybe a bit of a simplistic explanation, but that's all what I know about it. And it's due to the fact that I follow these lectures of Raoul van Kaanigen.
Thank you, Remco. On that very point of the Japanese legal choice, Margaret wants to react. I give you the floor, Margaret.
I just put a quick little note. I mean, my understanding was that much of it also depends on education and legal exchange, and that there were many more Japanese scholars trained in Japan than in France, and making the German model more easily transportable as a result.
Well, I would say this changed. So after Sedan, the Japanese didn't go to France anymore. The links with France were very strong before 1870. But that changed after 1870, because indeed then the German model became very influential, and Japanese scholars indeed studied, like they still do, I think, in Germany. They speak German, they don't speak English so much. So there is really now a very strong tie. Yeah.
Thank you. I turn now to Athena Stafila, who wants to come back to the influence of national procedural codes and models in Europe's countries in the future. Athena, I give you the floor.
Thank you. Thank you, Professor Carrier. I want to ask a question about the European civil procedural development. What will be the future? What will be the influence in the future of these national procedural codes and models in European countries, especially under the developments of an autonomous European civil procedural system? Will we have a hybrid system of German law, French law, and common law solutions mixed in a uniform solution in directives, in future directives, or we'll have a historical turn to a uniform system based on autonomy? This autonomy comes in many theses and articles in first place. We have the European Court interpretations, for example, based on effet utile interpretations, autonomous interpretations forwarding the economic liberties in European law. They interpret all these civil procedural directives based on autonomous means of interpretation and methodic. So what will be the future of this comparative rich tradition in modern European civil procedure? That's my question.
Thank you.
Thank you. Thank you. Well, you make me think a little bit about my father, who used to say, if I could predict the future, I would be a very rich man. But of course, it's a good question. You're referring to European law and European initiatives. I think that is not so much the issue or the problem. The problem is national civil procedure. What will be the future of national civil procedure? And in that area, I see, of course, certain movements influenced by Europe. But all in all, I think we still have very national civil procedural models in all the member states of Europe. Maybe sometimes Europe is influential in redrafting procedural legislation. We've seen that, I think, in Greece as a result of the austerity measures. So maybe sometimes in that field, Europe interferes. But all in all, when you look at the whole of Europe, I think the states are still very autonomous. Obviously, when we are talking about cross-border cases, this is different. There is some legislation. But the problem, of course, with that legislation is that it's sometimes not very successful. So what is the future? Well, I think the future, the near future will remain, I think, like we are at the very moment. I'm very interested in seeing what the reactions are as regards the model European rules. But I can already mention that, for example, in my country, when you read the rules on res judicata, which are apparently best practices in Europe, well, there is some hesitation. And the rules say, well, res judicata should be applied ex officio by the judge in the next dispute between the same parties. Whereas in my country, the tradition is opposite. and for very good reasons, which I cannot explain right now. And there the rule is, well, res judicata has to be invoked by the parties. And if the parties don't do so, earlier judgments will not be taken into consideration between these parties. And I think people will not be convinced so easily. So what will be the future? I really can't say. The future will tell her.
Thank you, Remco. And now just a small step to Athanasios Kaisis. Athanasios.
Thank you very much. First, Remco, thank you very much for your excellent presentation. Speaking about the influence of the French civil procedure law on civil procedure code in 19th century, if I'm not wrong, we have to think about this influence not only in Geneva, but in Bayern. The Bayerisch civil procedure is based on the French code civil procedure. And the second step, which maybe we can mention, is that in that century, some years later, 1834, von Maurer introduced this Bayerisch ZPO in Greece, into Greece. Yeah. So we have this combination of French, German, Bayerisch Recht, law, and till today we have to see the standard works of all those countries in order to interpret our civil procedure correct. Thank you.
Thank you. Yeah, I forget to mention that, but indeed the German influence in Greece is also very large. And you were in the same position as we. When I was a student, we had to study French works on civil procedure. Nowadays, that's less the case, because I think the procedural model has moved on in the Netherlands now due to German and even American influence. But we are, as small states in Europe, I think, in a comparable situation. True. Thank you.
Thank you. Michael Bowden wants to put a question.
Thank you very much, and thanks for a very inspiring lecture. Now, I was noted that you mentioned the American influence at the end of your lecture, and that's something which kind of happens today, and that not so much through legal reform, but informally through cultural influence. You know, at least in Sweden, where I teach, the legal education is rather theoretical. They don't visit courthouse so much. But all of my students have seen hundreds of courtroom dramas on television. And according, I had the opportunity to discuss this with Swedish lawyers, judges, and they confirmed that the young Swedish counsel now start behaving more aggressively, make objections of various kinds, and even start relying on such concepts as inadmissible evidence, which is quite foreign to the Swedish law of evidence, where we don't have kind of that idea that some evidence which is relevant but it's not admissible. So I wonder, what do you think about that? Is it does it play any role in Europe today? The cultural influence to media and fictitious movies, courtroom movies, and so on.
Well, the thing I can say, when a Dutch lawyer tries to do that in a Dutch courtroom, the judge will very quickly interfere and explain to the lawyer that the situation in which he is very different from the American courtroom. So I'm not sure if it will work in such a way. What I noted in the Netherlands was, for example, the interest in class actions in the US. But maybe to deal with very European types of things that cannot be solved by the state. Of course, I think that in America, class actions function in a completely different environment, where the state is at a distance, where compensation schemes organized by the state are very often not existent, like we have in Europe. So I guess the types of class action or the group litigation we have and group settlements we have in Europe are very different. But I can't deny that the Dutch model has been inspired by America. And that's probably also why many other European states don't like this Dutch approach. The German reaction, for example, was very strong against what happened in the Netherlands. So yes, there is an American influence, although the rules or the instruments then function in a different environment and they try to achieve different aims. But the general European reaction, I think, is not very favorable. When I look, for example, at what the Germans had to say about the opt-out scheme that the Dutch embraced. They didn't like it at all. Yeah, it's very difficult for me to say more about this, but it's a very, very interesting question indeed. Yeah, yeah.
Thank you, Remco. Regarding the US, I'm delighted to give the floor to Judith.
Hi, thanks. My internet stopped and started, so a little not so perfect US technology. So thank you. I was puzzling as I was listening. Actually, what came to mind was Jeremy Bentham, who talked about judges and company, because the narrative and the histories are mostly about law professors and jurists of various kinds, and not much about the users, consumers, people who are involved. And so, although your account is also deeply entrenched in political and social movements, it is focused on how the legal elites are interacting and making the models. And now the question is, what about where, if any, were the pressures coming from the users of the system? And then obviously several of the questions have talked about the contemporary issues where we have a radically different set of users pushing for things like class actions or collective actions of various kinds. So if I flash back to the centuries that are your center, where are there users who are participants in shaping these rules, or is this really an elite project? And then we get into who speaks what languages and seeks what victors or the like, but where are the participants in the system, and or are we really just talking about a system that is so narrowly sliced that one can equate the shapers with the users?
I think that is the answer. That's the answer. It's an interesting issue, of course. It's also a very modern approach. Well, modern, what is modern? But we are interested in the users of the court system. In the 19th century, of course, the users of the court system was a very small group of people, especially in civil procedure. And indeed, I have the feeling, as you say rightly, and not only the feeling, I know for sure, that the ones who used the court were also the ones who were making the procedure, who were shaping the courts. And the people in parliament who discussed about procedure were later on litigating before these courts. And the ordinary people, or however you want to describe them, well, wouldn't have access to court.
If I follow up on the trajectory of the people who were pushing you to the 20th and 21st century, does the variable of another set of participants, all the folks on the screen plus lots more, affect an understanding of what to expect from or how procedural systems will be shaped currently and moving forward?
I think that well, let's say when we look at the second half of the 19th century, we see reforms in the area of civil procedure. And these reforms, especially in Austria, are aimed at what are they aimed at providing access, I think, to larger groups in society. And that then also means that judges are trying to compensate for the procedural tactics of the more affluent litigants. So the judge becomes much more prominent in the civil process. And I have the feeling, but I have not researched that in depth, that it is related to a fear. And why was the movement of laborers so strong and successful in the second half of the 19th century, beginning of the 20th century. There was a fear by the ruling classes that there would be revolution. They looked at 1848, what happened in France. Obviously later the Russian Revolution became important. So I think that these reforms were probably not so much instigated by the idea that you needed to accommodate the court users. Well, you needed to accommodate them, but the aim was not to make it the aim was not to make it easier for them or to make it more comfortable for them. But that was also the aim. But the aim was to prevent social unrest. I think that was the aim. And then later on, but I think then we are only in the 1960s. Then indeed, the approach you just sketched becomes, at least in Europe, becomes prominent. Court users are being looked at, but still, that's a perspective that is only discussed to a certain extent in Europe. And my colleague Uzelac from Zagreb, he always emphasizes this. Look at the users. We should look at procedure from the perspective of the court users. But the fact that he repeats that so often probably means that in Europe we often forget this. And this may be different in the US. I'm not sure about that. I hope this answers it a bit, but obviously my answer is not.
No, it's totally important to start thinking about the variables in shaping these systems. And you taught us that a variable that we hope is au courant today was collapsed into the equation of the elites in and creating the court system. There's a law professor in the US, Mark Galanter, who for us famously talked about how repeat players play for the rules as compared to the one-shotters who come in on the last century. Thank you.
Thank you.
Thank you. Thank you, Judith. Thank you, Remco. We remain in the field of the emergence of the social question during the 19th century. Remco, I think you want to put a question about this dimension.
Yeah, Remo. I had already put my question in the chat when Judith intervened, but without reading my question, Judith read my mind, and because I was and I guess Remco has already answered the question. I can again read the question aloud. How do you see the avenues for doing historical research on the impact of the Industrial Revolution and the appearance of a new working class in the field of civil procedure? Keywords: the works of Anton Menger in Austria, the appearance of trade unions, the collective dispute resolution. Would be this an interesting research field, or would it be difficult to find material and possibility of doing research in this field? How do you assess the possibility to doing historical research? For my perspective, would be very, very interesting, because the appearance of a new class, social class, it was a truly transnational phenomenon at the time, in the end of the 19th century, in England, in France, in Germany, and so on. Remco, thank you.
Thank you.
That's a very interesting remark. I know that some of our Austrian colleagues have already discussed the ideas of Anton Menger, who, if I'm not mistaken, was a social democrat and also the teacher of Franz Klein. And indeed, I saw in the discussion, well, Burkhardt said, well, the reforms in Austria must be put into the perspective of the Habsburg Empire and the wish to centralize, etc., etc. But I think at the same time, these more social ideas played a role, because it has been demonstrated that indeed Klein, although I think he was not a social democrat, but he was very much influenced by the ideas of his teacher. And so the idea being that civil litigation has a societal perspective, a social perspective. And that, of course, justifies the change in the position of the judge. In France, with a very liberal approach to matters in 1806, it could be easily justified that when you have a civil dispute, well, the state or the judge should not interfere. You were free to settle your dispute in the way you like before you went to court. When you go to court, that remains the situation. And I think it is Klein's and maybe Menger's achievement to show that no, civil litigation is not only about a private dispute between individuals, it has wider significance. And that idea coincides, of course, with these very important changes in society and in the economy, which you just mentioned. So it might indeed be a very interesting research to see how procedure and society interact. And it's not without a reason that you probably remember that famous phrase of Karl Marx, who said, well, civil procedure is the most important part of the law because it gives life to the law. Without civil procedure, civil law would be something, a dead corpse. That's maybe the way I should describe it. So that's interesting that even Marx was interested in procedure.
Thank you.
Thank you.
Thank you, Remco. We have now to change a little the perspective with Shala Ali, who want to put a question about the reform project in Global South. Shala, I give you the floor. No. Well, I turn to Ramon.
Thank you, Louis. Thank you for the excellent presentation. My question is, J.A. Jolovich starts its excellent book on civil procedure by telling us that we should not take civil litigation, the concept of civil litigation, as something granted, that we actually know what we are talking about. And my question is, you describe all these reforms in the 19th century in different countries in Europe. And I was wondering if the reformers, the people that work on those, has had a shared intuition or a shared definition about what is civil litigation, what is civil procedure aimed to regulate, because it seems possible that they thought about different things, whether bankruptcy is included in civil procedure, under civil procedure, family law disputes is including under civil procedure, and different other things. So that is my question, whether they knew or had a shared concept about what civil litigation is.
Thank you, Ramon.
That's a good question. That's Professor Jolovich, Tony Jolovich, indeed says, well, before we start our comparative work, we need to describe what civil procedure really is. And then he says, well, it's a procedure that is started voluntarily by the claimant. It depends on the wishes of the defendant, because if the defendant pays, there will not be a civil process, and so on and so on. I think he gives that definition, especially because of the huge differences between England and Wales and the continent. He also tells in this article that his main problem is the existence of administrative courts, which are, of course, the result of the French Revolution. In England, also what we would call administrative cases are being litigated according to civil procedure. The civil procedure rules apply. And that is different in France and in the Netherlands, and, well, where not, I would say, on the European continent, where we have a special jurisdiction for administrative cases. So that problem is discarded when we leave out England and Wales. We go to the European continent. I've been concentrating on the European continent. And then, of course, there may be small differences of opinion. Does family law belong to civil litigation? Is that litigated according to the rules of civil procedure? But I think these differences are minor. And the big difference is indeed between the understanding of what civil procedure governs in England and Wales, or in the common law maybe, although I'm not completely sure, because Jolowicz talks about England and Wales, and the European continent. And so in the 19th century, I feel, well, I don't have to worry too much about this. Although you're right, I should maybe a little bit, because, well, there are some differences, of course, in the understanding of what civil procedure governs in the different states of Europe. You're right. Yeah. Thank you.
Thank you, Ramon. Thank you, Remco. Is Shala Ali back? No.
It's late.
Shala asked, can we speak of a model procedural law to be guided by in-law reform project in Global South, at least one for each of the legal families, civil law, common law, and mixed jurisdiction? Are there any comparative law studies findings on this?
That's a very long question, Louis.
Yeah.
I'm going to have a look at this.
And you have 3 minutes.
Can you speak of a model procedural law to be guided in law reform? So a guiding model, I guess, a model that is used in law reform projects in Global South. Would that be the south of Europe?
World, I think.
Yeah, the world.
Global South.
Yeah. Well, the only thing I can say, of course, is that in everywhere in the world at large, of course, we have the models that have been influenced by either France or by England and Wales. So I don't think that at the moment the procedural systems in parts of the world outside Europe show a very different, show very different family relationships. In Indonesia, they have still, to a large extent, the rules of Dutch civil procedure, which is related, of course, to the French procedural model, especially the old rules. Whereas in parts of Africa, of course, we all know that they have copied or maybe not copied, they have been forced, that has been forced upon them, the English rules. This is the result of colonialism. What I find surprising, of course, is that they kept these models. It's a little bit like what happened with the French model in Europe. In the Netherlands and in Belgium, it was, so to say, forced down our throat by Napoleon. But when Napoleon was defeated, everyone was so happy with the existing model that it stayed. Well, apparently the same development can be noted in former colonial territories. They keep the Western models, even though the colonizator, how do you say that in English, the colonial power has disappeared. That's interesting. But I don't think that outside of Europe there are different models. Maybe in the area of religious law, that's of course something else. But I'm not sure if most civil cases are not governed by religious law, apart from family law, maybe. I find this a bit difficult to answer, and maybe if Mr. Ali would have been present, then he could have explained it a bit to us.
Okay, thank you. Thank you, Remco, for your kind availability to the question and your rich answers. It's time now to close this second part of the webinar and the whole meeting. Thank you all for your participation in this very dynamic and fruitful sixth session of our introductory webinars. Now let me wish you a very nice weekend and see you later. Bye-bye.